Welcome back to the Dean Obeidallah Show. We're live here Friday, October 6th. Right now, very happy to have our friend Glenn Kirschner back, former 30-year federal prosecutor, served in the U.S. Army and JAG Corps, legal analyst with NBC and MSNBC, and of course, his wildly popular YouTube channel, Justice Matters with Glenn Kirschner. Glenn, welcome back.
Dean, great to be with you.
So much legal stuff. We could do hours just on Trump's legal garbage going on. So let's start with the breaking news from last night. ABC News reported that Donald Trump told a person that we know his name now, that it's the head of Pratt Industries, I think it's Andrew Pratt, Australian billionaire, about what they think they're dubbing it potentially sensitive information. The reporting is that Trump leads into Pat and said to him about the number of nuclear warheads they routinely carry on our submarines and exactly how close Russian submarines have to get, how close we can get without them being detected. But the point is, he's telling this person who has no security clearance, if this is true, are secrets. What's your reaction and what kind of crimes jump out at you at this?
Yeah, I mean, what's a couple of more espionage crimes among friends, Dean? Really, because he's been shown to have compromised and disseminated national defense information, which are the buzzwords for violations of our nation's espionage laws. He was caught on audio tape doing it up at Bedminster. This is more of the same. Doesn't mean we shouldn't be shocked and alarmed. I am disgusted that no judge, no prosecutor, none of our institutions of government are doing what they do every single day in this country from coast to coast and border to border. They detain people pending trial who pose a danger to the community. Tens of thousands of people are sitting in pretrial detention as we speak, Dean. And I would venture a guess that none of them are as dangerous to our nation, to our community, to our society as is Donald Trump. And yet nobody wants to use the rule of law as it was intended to be used and detain him pending trial. And I can't wait to talk about what we should make of Judge Engoron's gag order. And I'm sure we'll be talking about that soon. I don't want to jump ahead of the narrative here.
But to touch on something you just raised, that, when they put Jack Teixeira, the young guy who had at the time one count of espionage for fun, disclosing information online, ends up getting two counts, and a reality winner. When I went back and I wrote about it, the judges, because the prosecution was concerned that they might know more information and share it with others. Well, Donald Trump is very bitter. And this is an angry person who wants retribution, not just against Joe Biden, but against the United States of America. And if he were to lose and he's still walking around free, he's a great threat to revealing information, or even now, for just if it's going to help him in the campaign. Isn't that more of a reason why he really should be held, objectively speaking, not because we despise the guy, but objectively speaking, being held for fear that he can relay or share more of our national secrets?
Yeah, there is no rational argument against detaining Donald Trump pending trial. There are lots and lots of arguments in favor of it. We should apply the law equally and even handedly as it was intended to be applied. And the standard is, if there is clear and convincing evidence that somebody is a danger to another, to the community, to the society, I would say in Donald Trump's case, to our democracy, he should be detained pending trial. And the fact that judges and prosecutors are taking extraneous factors into account, something other than the facts and the law, in declining to do what the law says should be done, is so dang disheartening.
No, I can hear it in your tone. By the way, in regards to this new reporting on Trump sharing this information with the guy from Pratt Industries, who then in turn shared it with others, does Jack Smith's team have to amend the complaint to a superseding indictment if they want to charge him, or can they leave the indictment the way it is? And is this still admissible if he's not charged with this?
Yeah, the answer is they can do both things. But here's the thing. When I read the ABC reporting, it said that the FBI, the DOJ, has interviewed this character, Pratt, multiple times. And my sense is that was some time ago. So yes, ABC News, which I believe broke the story, may just have learned of this from sources. But I assume Jack Smith has had this for quite some time and decided whether he wanted to include it in the indictment that the grand jury returned in Florida, or if he just wants to use it as what we call 404B evidence. evidence of uncharged misconduct that shows something relevant to the charged crimes like motive, plan, opportunity, absence of mistake or accident. There's a whole bunch of reasons you can use this kind of thing as admissible evidence, even if it's not specifically charged in the indictment. I assume Jack Smith has already made those decisions.
And that's a great point, because it's reporting now. It's new for us, but not new for the prosecutors or FBI. So they could have could have put it in the indictment. It's not a brand new thing for them. I'm chatting with Glenn Kirschner. So Glenn, let's talk about the New York case here. And, Donald Trump stands outside of the courtroom where the judge is in his chambers, not far away, demeaning the judge, calling the judge corrupt and a liar, and then demeaning in racist terms the Attorney General of New York, Tish James, and even posting images about a law clerk. And everything Trump is doing is trying to delegitimize the court, the prosecutors, and our entire judicial system. And the only thing the judge does is say, don't talk about my law clerk anymore. What's your reaction to that?
So I have a couple of reactions. First of all, I'm glad Judge Engoron issued what I would call a snap gag order. Why do I call it a snap gag order? Because he didn't ask for motions to be filed about whether he should impose any restrictions on Donald Trump's speech or posts. He didn't ask for reply briefs or responses to the reply briefs. He didn't set it for oral argument. He didn't take days, weeks, or months to make a decision. He instantly issued a gag order saying, you will not talk about or post about my staff. Here's the thing, Dean. I embrace that. I applaud that. But why does it take somebody close to a judge, somebody important to a judge, like his law clerk, being threatened by Donald Trump to inspire a court to act to protect who? His law clerk and his staff. How about the other judges, Dean? Protect the witnesses that Donald Trump endangers every damn day. No, those witnesses aren't close to the judges. So you know what? I'm almost bothered as much as I am heartened by Judge Engoron protecting his own clerk and his staff when all of the other judges are declining to protect witnesses, grand jurors, prosecutors, and judges, and all their family members. Why can't we treat everybody with the kind of concern Judge Engoron treated his law clerk? Now, let me hasten to add that I'll be in court on October 16th when Judge Chutkan is going to take up this issue, but this issue is being taken up really in the opposite way that Judge Engoron issued that snap gag order, which was entirely lawful, necessary, and appropriate. But, Dean, at what point do our institutions of government, our courts, our prosecutors, take all this garbage seriously and protect people and protect our democracy and protect the integrity of our system and protect all future jury pools against being tainted by Donald Trump? All of the tools are there. We have the ability to do all these things to stop Donald Trump, and yet we decline to deploy these tools. I wish to heck I could explain to people's satisfaction why that is, but I just can't.
No, and I share your frustration. I mean, I wrote about for MSNBC earlier this week that it's long past time Donald Trump be treated like any other American. He's a former president. He's not a president. He's just a guy applying for a job right now. And the idea that we're going to allow him to do more actions that are corrosive to the institutions of justice, which he wants to corrode anything that could be a check on him and hold him accountable, and on the prosecutors and on witnesses and on the court system, and nothing happens. And why doesn't that send a message to everyone else? You can do the exact same thing, and they're going to find out you can't. But getting back to Judge Chutkan, so that case there's a motion pending to have a gag order. It's going to be October 16th in a couple of Mondays from now. What do you think she'll do?
Oh, she'll issue a gag order. I have absolutely no doubt she will issue a sort of narrowly tailored set of restrictions telling Donald Trump what he is prohibited from saying and posting, and then I assume she'll take up at some point Donald Trump's motion to dismiss, which was just filed, which usually I urge people to read court filings. I'm urging people not to read this one because, Dean, as I was reading it, if there were people sitting around me, I was reading it to myself, But if they listen very carefully, they could probably hear my brain cells dying and hitting the floor, because it is just that idiotic, the things that they put in this motion to dismiss. I understand they're trying to bubble up any issue they can to the Supreme Court. These issues are not going to make it.
And Donald Trump filed two different motions, his lawyers, for dismissal, one in New York and one in the January 6th case. So so Trump's motion to dismiss, arguing that whereas here the president's actions are within the ambit of his office, he is absolutely immune from prosecution, and Trump's actions to ensure election integrity are within the outer perimeter and official responsibilities of the president. That was the first argument. The second one is just laughable. So what is your reaction to the idea that he's saying he is absolutely immune from prosecution?
Yeah, this is nothing more than him pulling out and dusting off Richard Nixon's line that if the president does it, it's not illegal. It's nonsense. That's the nicest thing I can say about it. I don't think for a minute the Supreme Court will create a new doctrine, because mind you, you can read this pleading forward and backward. There's no legal authority for what they are claiming, that a president gets to commit crimes while in office with impunity. So I don't think the Supreme Court will take this up. And here's why, Dean. Not because I have any confidence in the integrity or the thoughtfulness of constitutional interpretation of the Supreme Court, at least the conservative bloc. I have zero confidence in them. But you know what I am confident of? Their own determination to cling to their power and their supreme position over and above a president. They can strike down as unconstitutional something that a president and his executive branch do. And if they were to grant a president absolute immunity from criminal prosecution, he could order the block of Supreme Court justices that he doesn't like summarily confined, and they would then have to rule he gets to do it. Come on now. You know the Supreme Court is not going to give its own power and supreme status away to an aspiring dictator.
No, I agree. There is a judicial self-preservation, because if not, you're just a person walking around in a robe. You know, it's not that impressive. He says 9 people in robes walking around. Like, why are you wearing robes? It doesn't even matter anymore. Yeah. Like I love this part of the brief. They argue that since Trump was acquitted of his charges in the trial in the Senate, he remains immune from prosecution. I can't even believe a lawyer put that in writing. I mean, what a joke that is.
So here's the thing. What we didn't know, Dean, is there's this magical, unseen, unheard, unwritten double jeopardy provision that if you are, if there are articles of impeachment passed in the House, but the Senate in the trial decides not to convict you, there's magical double jeopardy that nobody knew about. Nobody, not in the Constitution, not in the law, not in any precedent. Who knew, Dean? Who knew? These are some creative mouthpieces Donald Trump has.
It's a joke, folks. There's not there. The only argument would be double jeopardy, as Glenn is saying, but it doesn't attach here. There's not even a chance of a loss of liberty, and it wasn't a judicial proceeding. It was a political proceeding. That's what impeachment's a political proceeding. It's not a judicial one. But Glenn, I saw some analysts talking about, because it's an application for immunity by way of this motion, that it could delay the trial date. What do you make of that?
Yeah, it can always delay a trial date. Do I think it will? I don't think it will. First of all, Judge Chutkan is going to move through this like, you know what, through a goose. She's going to deny it very promptly. I believe the District of Columbia Federal Circuit Court will affirm that denial. Donald Trump will seek review in the Supreme Court. I don't think the Supreme Court will take it up. But mind you, it can work its way through the appellate system, 1, quickly, and 2, without any court ordering a stay of the trial court proceedings. It can just go along on the parallel track. We're seeing that down in Georgia, right? Where the RICO prosecution in the state court continues to move forward through the pretrial stages, even though the Meadows and all these knuckleheads are trying to, get the federal court to transfer the case. They're all unsuccessful. But it doesn't put a stop to the Georgia state RICO prosecution. The same thing can happen in Donald Trump's federal prosecution in D.C.
And that's a great point, that because Trump's like, oh, we're going to appeal this, the key issue for us is, does it stop or force an adjournment of the trial date? If it doesn't, they're still on that track because, yeah, I mean, the judge can give a decision on this at the end of the month or early next month. Trump appeals. Hopefully the Court of Appeals in DC Circuit takes that pretty quickly. And then you have to hope the Supreme Court doesn't even just allows it to be affirmed. Now, what if the Supreme Court were to say we're going to hear it? I mean, could it delay things then, or no? It just continues.
It certainly could. The Supreme Court could issue a stay of the proceedings in the trial court, a temporary pause while they take it up. But again, I am confident enough in the Supreme Court's determination to hold on to its power. I don't, the one place the Supreme Court has been fairly strong on, it's the challenges to the election. It is Donald Trump's stupid power grabs that really have no support in the case law or in the Constitution. They've been pretty strong in knocking that stuff down and refusing to accept those cases for review. So I don't think they're going to interfere here. I think they're going to let the federal trial in DC just kind of, take its normal course. And then in the event of conviction, and he will be convicted just as quickly as Peter Navarro was convicted, because, the jury didn't have time for a cup of coffee before they convicted Peter Navarro, made his head spin. The evidence against Donald Trump is just as strong. He'll be convicted. And then the question becomes, in the ordinary course of an appeal, what does the Supreme Court do? Do they take it? Do they mess with it? Do they try to overturn the conviction? I think the answer to all those questions are probably no, but that's when we'll be talking in earnest about appeals.
And if Trump was convicted in the trial in DC, the January 6th case, and the judge sentenced him to several years in prison, let's say, which would be fair, then if he appeals in that scenario, is he like Steve Bannon just walking around, or how does it determination then when it's a longer prison sentence?
Yeah, I know a appointed judge, Carl Nichols, put Bannon on release pending appeal, which was an outrage, really. The ordinary course is that once you are convicted and sentenced, you report to the Federal Bureau of Prisons to begin serving your sentence. I think Peter Navarro will be confined after he is sentenced. I don't think he will remain at liberty pending appeal. I don't think Judge Chutkan will allow him, in the event of conviction and a sentence, to incarceration. I do not think Judge Chutkan will allow Trump to remain at liberty pending appeal. But, all of these things are maiden voyages we're taking. So we'll see. Interesting.
And by the way, in New York, and it didn't get much press at all, but the lawyers there asked the judge to dismiss what we know was the hush money case, and they actually argued, and I didn't read the brief, I just read the articles about it, that President Trump's been prejudiced by this happening during the 2024 election, and that Alvin Bragg, or the Manhattan DA before him, had this for years, and they're just bringing it now. I don't even know what the legal argument is here, to be honest.
Oh, it's a motion to dismiss based on election interference. Well, if I had a nickel for every time I litigated that in 30 years, Dean, yeah, there is no legal argument that election interference equals dismissal. But more fundamentally, Dean, he's always screaming election interference. Frankly, that's part of why he just asked Judge Cannon down in Florida to delay his prosecution until after the 2024 presidential election. I actually maintain that what Donald Trump is doing is election interference. And here's why. Donald Trump will go on trial in Florida for unlawfully retaining classified information, obstructing justice by defying a grand jury subpoena for the return of the documents he'd stolen, and violations of our nation's espionage laws for disseminating national defense information. He wants those charges to basically be held in abeyance until after the election. I believe, Dean, that the people, the voters who go to the polls in November of 2024 have every right to know that if they're intending to cast their ballot for Donald Trump, whether they're casting their ballot for a convicted felon who almost destroyed our national security, or a fully exonerated innocent man who was found not guilty by a jury on all counts. That's the kind of information that American voters need. And trying to prevent them from getting that information is election interference, just as it is up in New York when you paid off playmates and porn stars to try to bury deeply damaging information that the voters were entitled to know when they were assessing whether to vote for you or not. What Donald Trump is doing is election interference.
That's our friend Glenn Kirschner laying it out. Absolutely correct. And that's what it is. And if he was an innocent person, he would want to have the trial right away. You would think, right? I mean, and he's not. He's just dragging out. And by the way, so Trump's lawyers made a motion in the Florida case, in the espionage case, a formal motion to put everything off. They didn't argue about this time, the election coming up. They talked about how difficult it is to get all the documents and everything else. What do you think Judge Cannon's going to do here? And she already agreed to stay all their deadlines. So it looks like she's willing to at least put off certain deadlines. She hasn't put off the trial date yet, but how do you think that's going to end up?
Well, I think we have to approach that question against the backdrop of Judge Cannon already having abused her judicial discretion to do an enormous favor, though, for Donald Trump, right? She was reversed for acting in a way the law did not permit and throwing him a huge solid, right? So that informs my suspicion that she will probably continue to kowtow to Donald Trump and push the trial date beyond the 2024 election. I hope she doesn't. I don't think I know quite enough about all of the various discovery issues, what has been turned over, what has not yet been turned over, and Dean, if it hasn't been turned over, is it because Donald Trump's lawyers are dragging their feet on getting the information to the Department of Justice so they can assess the appropriate security clearances? I don't know. There's a lot in the mix down there. I will say I don't have much faith in Judge Aileen Cannon.
I would have look from the outset when she said her trial date, there were people like, oh, this is great. She didn't do what Trump wanted. I'm like, wait. She's going to do exactly what Trump wants. We're not going to have this trial before Election Day. And even though it's Florida, it's not DC, that if this case is the way it looks to most people, that it is, there's almost no defense really for Donald Trump or no defense at all. He gets convicted. If he gets convicted in Florida, he can spin everything he wants all day. That's really bad for him. So look, I think it's convicted anywhere. So I think at the end of the day, we should not be disappointed when Judge Cannon puts his off beyond the trial date. She's going to do that. But let's turn to Georgia because it just doesn't end. So I was reading that the Fulton County DA is talking about pleas for certain people, which is normal. You're a former prosecutor, and that they're considering plea offers to Sidney Powell and Kenneth Chesebro, who are the first two. Their trials will be coming up at October 23rd, if I remember correctly the date. That is this normal? Anything about it interesting to you?
Yeah, so I had for context, I had a case, a RICO case, where the numbers were pretty closely aligned with the numbers we see down in Georgia. We indicted a little over 24 RICO defendants. We extended a bunch of plea offers, some with cooperation if we wanted to flip the defendants, some without because we didn't need what they could bring to the table. So we just called them out. We got it down to 13 defendants. We then did 3 waves of RICO trials because we can only try 6 at a time in the courts of DC. That's what the U.S. Marshals have always told us. So what I thought was really important was the first defendant down in Georgia to flip is Scott Hall, I think is his name. He's the bail bondsman who was charged with a bunch of crimes in connection with compromising the Coffee County election equipment. Those are crimes that Sidney Powell is also charged with. So I have to believe, Dean, that the Scott Hall domino will fall directly into Sidney Powell, hopefully causing her to topple, plead guilty, accept responsibility for her crimes, and cooperate against the other co-conspirators, co-defendants. I don't know if that will happen or not, but once one RICO defendant, co-conspirator flips, it typically will set off a chain reaction. And what we're seeing is Fani Willis extending a bunch of other plea offers. And I would bet a buck that we're going to see more co-conspirators begin to accept responsibility, plead guilty, and agree to testify against others. Maybe she'll get it down to 13 the way we did. Maybe she'll get it down lower. But then you'll ultimately see probably at least a couple of batches of trials with the remaining co-conspirators. But everybody needs to tune in to the must-watch TV beginning on October 23rd. I guess it's must-watch streaming now because it'll be live streamed.
Right.
Because Fani Willis, even though there will only be 2 defendants at the table, Sidney Powell and Kenneth Chesebro, unless one or both plead guilty, Fani Willis will present the entire RICO case to that jury, the crimes of all of the co-conspirators, not just the 2 at the table. So we're going to see the evidence showing that Trump, Mark Meadows, Giuliani, Jeffrey Clark, and John Eastman and Jen Ellis. We're going to see all their crimes. And here's the thing, Dean, their lawyers won't be at the table. So there won't be anybody knocking down the evidence of their crimes. Just the lawyers for Chesbrough and Powell will be knocking down the evidence of their crimes. And they may actually prop up the evidence of the crimes of Donald Trump and Giuliani as a way to deflect and say they're the more guilty people, and see those empty chairs. That's where they should be sitting, ladies and gentlemen. Hold them accountable in the future. Don't hold us accountable. We're lesser players. So there's a little bit of something for everybody in this trial. And I hope one or both go to trial on October 23rd so we can start to see the evidence for ourselves.
That's great. I didn't think of that point. You're a former prosecutor, and I'm glad you raised it. Very last point here. Donald Trump has endorsed Jim Jordan to be the next Speaker of the House. And I sent you my article. I appreciate that you shared it. But as the January 6th report notes, Jim Jordan was, quote, a significant player in President Trump's efforts to overturn the election. In fact, if you read the January 6th report, there's no member of Congress more involved. And I don't mean Jim Jordan just going on TV and lying. Yes, that's documented. He led conference calls days before January 6th. He was having personal phone calls with Donald Trump on January 6th, 2 of them. He was involved in plotting social media discussions to get people to go down to the Capitol. Jim Jordan was involved in everything. He texted Mark Meadows on January 5th, advising how Mike Pence should be pressured more not to recognize electoral votes. What's your reaction to the idea that Jim Jordan, who was involved in this insurrection, this attempted coup, might not now be the next Speaker of the House of Representatives?
Yeah, we have insurrectionists in Congress, and they're attempting to elevate one to the Speaker of the House. And, that will sort of continue to see us slouching toward the end of our democracy if we permit it. I loved your piece, and with your kind permission, today's Justice Matters video will be all about your piece and your observations about Jim Jordan and the danger it poses to have an insurrectionist who, among all of the parade of horribles you just listed, Dean, he also committed the crime of contempt of Congress by refusing to comply with a lawfully issued congressional subpoena. And now this hump is out there issuing congressional subpoenas of his own, expecting people to comply. This is bizarro world, right? Where up is down, in is out, black is white. So I hope he does not win the speakership. I don't really know who I would like to see win the speakership, but I know an insurrectionist is probably not the right person for the job.
And very last thing, when you look at what the January 6th report lays out in terms of evidence they gathered, a lot of it based on sworn testimony. I mean, is there a good faith argument to make that Jim Jordan is actually a co-defendant in Donald Trump's January 6th related crimes?
All day long, all day, every day. And the only person who knows for sure whether there's enough evidence to charge him is Jack Smith and his team. I'm quite sure they've been investigating the insurrectionists in Congress. Remember, 6 of them, they're not all still in Congress, asked for pardons because they knew they'd committed crimes on and around January 6th, and they wanted to get away with those crimes. Jack Smith can't turn a blind eye to all of that. So, the other thing that Jim Jordan has absolutely been doing is trying to cover up and prevent Donald Trump from being held accountable for his crimes. In a very real sense, he's been an accessory after the fact to Donald Trump's crimes by creating this Mickey Mouse committee on the weaponization of government. So I think there are any number of crimes that Jim Jordan may have committed, and I hope Jack Smith is going scorched earth after those crimes.
Glenn, I want to thank you, my friend. It's great chatting with you. I look forward to it. And check out Glenn's Justice Matters on YouTube. Follow him on Twitter and Threads and everything else. Have a great weekend.
Thanks, Dean.